For me, it's good evening, so I hope you're doing well. And we finally move into a brand new arena, the arena of civil rights. And I want to start off with an overview from your notes, and that is comparing where we've been, that is negative freedoms, and where we are about to go, positive freedoms. So the topic that I just concluded was civil liberties. And another name for civil liberties are negative freedoms. So with negative freedoms, they're individual liberties, are freedom from governmental power or regulation. If you want to summarize the last topic, whether we were talking about speech rights, press rights, religious rights, or rights as criminal defendants, the overwhelming trend, the overwhelming theme in the civil liberties section is that largely we have people who want to be left alone. We have people who do not want to be subject to the authority and power of government. And I gave you a lot of examples of cases where ordinary average people like you and I did prevail against the power of the national government, state governments, and local governments. So with civil liberties, it's a pretty easy topic. The emphasis is on individual liberty, and government is largely seen as an obstacle or as an adversary. The arena we're about to move into, civil rights, is a lot more complicated. It's a lot more problematic, and you may remember the first week my discussion about negative freedoms and positive freedoms, but I'm bringing it back in this lecture just to give you a basic orientation of the differences, because sometimes people interchangeably use the term civil liberties and civil rights, and I want to make sure that we're all on the same page here and that we're not doing that. Positive freedoms are more complicated for two fundamental reasons. The first is that with civil liberties, we were talking about individual liberties. And with civil rights, we're talking about group rights or our freedom to do something, right? We were talking about freedom from governmental power with civil liberties, but with positive freedoms or civil rights, we're talking about the right to do certain things. So it might be the right to vote. It might be the right to have equal access to public accommodations, bars, restaurants, theaters, gas stations, the right to have an equal education and to have desegregated schools, for example. The reason why this topic is more difficult, first, is that group rights are a little bit more elusive. Who gets to belong to a group and under what circumstances? The second is that the role of government is a lot murkier with positive freedoms. With civil liberties, government's an obstacle, some would even say an enemy, although I think that's probably overstated. But with positive freedoms, it may not be the government that is the obstacle. It may be other members of society, for example. You may be discriminated against by another group, and you may actually want the government to step in and to ensure that you are given equal treatment under the law. So the role of government is murkier with civil rights, and the notion of groups are perhaps murkier. I'm going to use two groups to illustrate civil rights. One is Black Americans, and I know the term that's usually used is either African American, or increasingly I'm hearing this term people of color. I'm going to use the term Black Americans, and I believe I told you the story earlier in class that for 3 years I worked for one of the foremost African scholars in the world, and I worked side by side with 4 Africans, and we were TAs together, and in deference especially to my best friend, you guys know how I rank everything, so my best African friend Jima from Ghana, I use the term Black Americans. So I start off by talking about really two legacies. The one that I'm going to talk about very briefly, and in fact it's more of a review, then it really is new material, although I will add a few things, and you will notice a few new things in your notes if you're following along. Certainly Malcolm X, I do think, had a profound statement when he said, "We didn't land on Plymouth Rock. Plymouth Rock landed on us." Certainly there is no question that the transatlantic slave trade distinguishes this group from other groups that came to America. I mentioned, remember, when we were talking about the Constitution, that the mental image that people have of slavery is that this was a sectional issue. And by that, that slavery was a Southern thing. And I told you that that's not true, that if you go back to the Constitutional Convention, if you go back to 1787, slavery was actually legal in every single state except for Massachusetts. So at the time of the convention, slavery was an American thing. Now, your notes mention that many early Africans until the 1660s, and certainly the first law that I have found legalizing enslavement for life came out of Virginia in the early 1660s. Many early Africans came as indentured servants, and there were actually indentured servants of a variety of colors and hues and races. And I think I told you that one of my German ancestors, one of the Barnheisers, came to America and was an indentured servant. He was in economic bondage for 7 years until he became a free person. The thing that distinguishes Black Americans, however, is that many of their ancestors were slaves for a couple of centuries. From the 1660s until 1865, we have 2 centuries of enslavement for life. Now, I want to get to the Constitutional Convention, and we went over this, but I just want to remind you of ground that we've already plowed much earlier in this course. I called slavery the constitutional silence of the convention. And the reason is that primarily Southern states relied on slaves economically. Even though some Northern states had a significant amount of slaves, for example, if you take a look at the 1790 census in the state of New York, more than 6% of the population of New York were slave. While that is a significant number, it is dwarfed by the 35% in Virginia or the 39% in South Carolina, for example. So when push came to shove, even though there were a couple of people at the convention that wanted to abolish slavery, Benjamin Franklin, the abolition of slavery was the last great crusade of his life, and he wanted to abolish slavery, but many delegates, especially those representing slave states, were unwilling to do it. And so as a result, slavery was only discussed on the margin. I mentioned how the Three-Fifths Compromise was really an attempt to balance political power between Northern and Southern interests. In other words, the slaves became pawns in this battle for political power between Northern and Southern states. And if you take a look at the 1790 census, it is remarkable how closely balanced political power was between Northern and Southern states. The second provision that we see in the Constitution of 1787 was that Congress was allowed to ban the importation of slaves after 1808, which they did. And they didn't obviously abolish slavery. We don't get the 13th Amendment abolishing slavery for well over half a century after that 1808 provision. But we do at least get the banning of the trafficking of people legally. There were people who trafficked illegally in slavery until really the Civil War, was getting ready to start. The issue of slavery then was left for history to decide, and I told you that people kept kicking this can down the road, that when 1850 rolled around, there were 30 states in the Union. 15 were free, 15 were slave, and when I talked about federalism earlier, you may remember I talked about the Missouri Compromise of 1850. The significance of that compromise, of course, was that the belief was that slavery and that question had been resolved forever. Well, the Supreme Court not only declared the Missouri Compromise unconstitutional, which is what I emphasized in the federalism section, but they also ruled that former slaves were not citizens. The assumption was that someday, if we abolish slavery, that the former slaves will become citizens. But Justice Taney in the Dred Scott case said that former slaves were not citizens. I mentioned earlier Justice Taney's infamous statement, which displays his racism. He was a slave owner. He came from a slave-owning family. And you may remember his statement in which he said, blacks are so far inferior, they have no rights which the white man is bound to respect. Because Dred Scott is not a citizen, he has no right to sue in this court. So what this Supreme Court case did was that it demonstrated the need not only to abolish slavery, which occurred in the 13th Amendment, but it also demonstrated the need that in the 14th Amendment, one of the provisions, and the 14th Amendment is a very complex amendment. I talked earlier, for example, about the Due Process Clause in the 14th Amendment that states, no state, right, shall deprive any person of life, liberty, or property without due process of the law. And that's the provision in civil liberties that the Supreme Court used to very gradually incorporate the Bill of Rights roughly from 1925 until 1972, with some exceptions such as the Second Amendment, which came in 2009. The civil rights part, though, of the 14th Amendment is just as important. And that part of the Dred Scott case was overturned by a constitutional amendment. So Justice Taney in 1857 says that former slaves are not citizens. So one of the provisions in the 14th Amendment grants former slaves citizenship, which overturns the Dred Scott case. So slavery was not adequately addressed by the Congress or by presidential decree or action or executive order, or really even by the Supreme Court in some sweeping Supreme Court decision. Instead, the issue of slavery was resolved in the bloodiest, most deadly conflict anywhere in the world from 1815 until 1914. The U.S. Civil War was the deadliest war anywhere on our planet during that 100-year period from 1815, the end of the Napoleonic Wars, until 1914, the beginning of World War I. And of course, the aftermath of this war was that Congress and the states would draft 3 landmark pieces of legislation called the Civil War Amendments. In the next recording, I'm going to talk about the 13th Amendment, which prohibited slavery, the 14th Amendment that I've talked about a bit, and the 15th Amendment, which was kind of a cruel joke played on early feminists. I'll talk about that later, but at least constitutionally gave black men the right to vote. In the next lecture, I also want to make a transition from slavery to segregation, which I believe has had a more contemporary influence on the country, and I will talk about that next.